right, so this video is going to summarize the divorce process from beginning to end. And I'm going to share my screen here to a Word document that summarizes everything. So initially, when a divorce is filed, there's a number of initial pleadings that need to be put together. Those are the summons, which is it's a document that lists some background information for the parties and puts the defendant. So the person who's filing the action is the plaintiff. The person who's not filing the action, the other spouse, is the defendant. So the summons is essentially putting the defendant on notice that the plaintiff is filing a divorce action. Then there's a complaint, which lists a lot of the background information of the parties, when they were married, whether or not they have children, if they do have children, their dates of birth, etc. It also lists the relief that the plaintiff is seeking: alimony, child support, if any, division of assets and debts. It essentially lists all of that background information. Then there are the notice of automatic orders. So the automatic orders are automatic court orders that are in place while the divorce is pending. And we'll get into those in more detail, but they basically say that neither party can, dissipate any assets. You can't cancel life insurance. You can't cancel health insurance, automobile insurance. There's a whole bunch of rules that you need to follow while a divorce is pending. Every case, you need to just put a blank appearance in the file, which is eventually given to the defendant. It's put in there so that they can, have an appearance form to fill out. An appearance form is basically a form that the defendant will fill out, putting the court on notice that they will be representing themselves, or if they're not going to represent themselves, their attorney is going to file an appearance on their behalf. And it basically puts the court on notice of the address of the defendant, so that if once an appearance is filed, if anything happens in the case, the defendant will be put on notice. Something will be mailed to them, etc. Now, some cases require a motion for order of notice. So if you have to serve a party, this is in few cases, but if you have to serve a defendant out of state, or you can't, well, let's start with out of state. If you have to serve a defendant out of state, you have to file a motion for order of notice, basically asking the court for permission to serve the opposing party by certified mail, for example. Or if you can't find a defendant, then you have to file a motion for order of notice asking for the court to grant permission that you serve by publication. And service by publication is now on the Connecticut judicial website. So the motion for order of notice is put together, and then the court issues the order of notice, which is essentially granting permission or denying permission, but it's giving orders regarding service of out-of-state defendants or defendants who can't be tracked down, so need to be served by publication. Then ultimately, when the case is initially filed, you're going to need to file one of these two things: a waiver of service form. So if you're not going to serve the defendant if you're not going to have a marshal serve the defendant, and you can instead have the defendant sign a waiver of service, which basically says, I'm aware of the divorce case and the fact that it's pending, and I don't need to be served. So they will have to go out and get that notarized, and then that is submitted to the court. Or if you have the defendant served, you give the paperwork to a marshal. Marshal serves the defendant, and then the marshal gives a return of service back to us, which is filed with the initial case. So just the steps of how it works: we first draft these initial pleadings and give them to the client for approval, make sure everything's done, and then we have to sign the pleadings. If we are representing the defendant officially in court, then we sign the pleadings. They don't have to sign anything. But if they're self-represented, then they have to actually sign these documents, and they also have to bring them to court to have the court kind of approve the documents before they're served. But if we are representing the parties, we don't have to bring the documents to the court. We just sign them. And then, so it's first drafting the documents, and in Connecticut, you actually have the defendant served before you file the case. So you would either give the documents to the defendant. Generally, we would have our client give them to the spouse and say, hey, I'm planning on filing for divorce. Are you willing to sign this waiver of service? Or we will give the documents to a marshal to have the defendant served, in which case, the service will be done and we will get a return of service back from the marshal. So once we've got once we've got all of these pleadings and the waiver of service or the return of service, and then at that point we e-file the case on the judicial website, and then at that point the case is pending. So those are the pleadings those are kind of the general mandatory standard pleadings for a plaintiff. Now, for the defendant, obviously you don't have to do any of this stuff. The defendant is actually getting served by the plaintiff. So really, if you're the defendant, we want to make sure we file an answer and cross complaint. And the reason we want to do that is because if, let's say, the plaintiff files a divorce case and then 6 months later they decide, oh, I don't want to pursue this anymore, I don't want to get a divorce, they can withdraw the divorce and then it goes away. And if we're the defendant, our client may say, all right, well, they don't want to pursue a divorce anymore, but I do. And if you haven't filed an answer and cross complaint, you can't still pursue the divorce because the plaintiff has withdrawn it, so the case is gone. So that's why it's important to file the answer and cross complaint, so that if a plaintiff does, in theory, withdraw the divorce, it doesn't go away. It remains a pending case based on the fact that there is an answer and cross complaint that has been filed. So those are the basic pleadings for the plaintiff and the defendant. And then there's some other standard pleadings that are filed by either side. And we're going to get into all this stuff in more detail in different videos. I'll show you the actual forms, etc. But standard pleadings that either party can file are a motion for exclusive use, Pendente, Lite. So Pendente, Lite are motions asking for, I'm not sure what Pendente, Lite means in Latin. I probably should know that, but it's basically asking for court orders while the divorce is pending. Because obviously divorce can be pending for quite some time, up to a year, and it can't just be the Wild West. You need some orders in place to keep things calm between parties who are going through a divorce. So one example is a motion for exclusive use of the house, Pendente Lite, and that's basically saying, hey, I want, I feel that my spouse should be ordered removed from the house by the judge so that, I can live there primarily and they live somewhere else while the divorce is pending. It's pretty difficult to have a motion for exclusive use granted. There has to be, a pretty extreme circumstance, yelling and screaming in front of the children, etc. Or if another spouse has already moved out of the house, then generally a motion for exclusive use is going to be granted so that they can't just come back or show up whenever they want and create problems. Then there's a motion for custody and visitation, Pendente Lite. So those are generally, whenever there's kids, those are generally filed right off the bat because, you want to start working towards figuring out a parenting plan for the kids. Ultimately, in a divorce, generally the people are going to be living apart from one another. So you need to start to come up with a plan of what the visitation schedule is going to be once the parents are living apart from one another. And sometimes during the divorce, they are living apart from one another, in which case you need Pendente Lite custody and visitation orders to figure out who's going to have the kids during what time periods while the divorce is pending. Now, for custody, there's legal custody and then there's physical custody. So legal custody is just, things like who's going to make decisions about where the kids go to school, where they go to the doctor, stuff like that. Legal custody is almost always joint, where the parents are making decisions, together about these major issues. In certain circumstances when, parties really can't get along with one another, they can't co-parent and come up with decisions. It might be joint legal custody with final decision making to one parent, or where they still have to collaborate with one another, but ultimately if they can't reach an agreement, one parent has the final say, or sole legal custody where one parent just has the final say and they really don't even have to collaborate with the other parent who does not have sole, who doesn't have custody. And then there's visitation. So the visitation is, generally, when the kids are spending time with which parent. And, it can be anywhere from a 50-50 parenting plan, where the parents are spending equal time with the kids, or, primary residence with one parent, and then something like every other weekend and one, dinner visit per week with the non-custodial parent. And we'll get into some more detailed parenting plans. And just, all of these motions can be filed by either party. Then there's a motion for alimony pendente lite. So if there's, sometimes a spouse who's not earning a living, and really relies on their partner for financial support, they may file a motion for alimony pendente lite to ask for financial support from their spouse, a weekly support order while the divorce is pending, so that, the non-working parent has the financial resources to pay bills or put gas in the car, etc. There might be a motion for child support pendente lite, which, similar to the motion for alimony, a parent may rely on financial support from their spouse while a divorce is pending. So we need to get those orders put in place. There's also a motion for contribution to household expenses. That's kind of a, pretty similar to motion for alimony or child support. It's, just asking for court orders about how the bills are going to be paid on the house, who's going to pay the mortgage, who's going to pay the utilities, etc. How they're going to pay it. It may be split 50-50. There's all sorts of ways that it can be done. Then, another pretty standard pleading is a motion for counsel fees. So let's say there's one spouse who controls all the money. They, all the bank accounts are in their name only, and they control all the funds, whereas the other spouse, they don't have access to money. In that situation, we're going to want to file a motion for counsel fees that basically says, okay, the husband has, a bank account with a ton of money in it that our client doesn't have access to pay for an attorney. So we would file a motion for counsel fees asking for a court order that the other spouse pay a retainer to cover our fees, so that the party who doesn't have access to funds can have representation. Another standard pleading is certification of notice. So this just if either party or the children are receiving state assistance, town assistance from a town, or Husky health insurance, then this form needs to be filed with the court, and the state basically needs to be put on notice that a divorce is pending. Then we've got the request for disclosure and production, and a notice of request for disclosure and production. So the request is basically a list of documents that we are requesting from the opposing party, tax returns, bank statements, retirement account statements, etc. It's basically a request that we serve on the other party, asking for, generally speaking, financial records, so that we can have all of the financial information we need from them in order to negotiate, get into negotiations. In a divorce, a lot of it is financial, so we have to have a full understanding of the financial pictures of the parties. Now, the request is not actually filed with the court. There's a corresponding notice of request for disclosure and production, which, is drafted and given to the other side at the same time. And we only file the notice with the court. We don't have to actually file the request. So these are a lot of the initial pleadings that are filed. And then after those are filed, really we're going to want as soon as possible to start to gather financial information. So that will include the financial affidavits. So in a divorce, both parties have to they have to draft and file financial affidavits. A financial affidavit is a document that lists, income, expenses, assets, and debts. It's essentially a total, financial rundown for each party. So we exchange those so that we have an understanding of the finances. And then we also exchange supporting documents that we need to kind of verify the information in the financial affidavit, make sure nobody's hiding anything, or just make sure we have a full understanding of the finances. So we would exchange all of that information. And then, with that, we would, in order to get a full understanding of the financial picture, we may want to go out and get some appraisals. So let's say there's a house, and we want to know what the house is worth. And you can't necessarily rely on Zillow or websites like that. So we want to go out and, generally speaking, have an appraisal on the house to figure out what it's worth. Now, ultimately, if the parties are going to just sell the house, you don't necessarily need an appraisal, because you can just say, all right, the house is going to be sold and the proceeds are going to be split 50-50 or in some other proportion. Or one spouse may get the first $50,000 from the sale proceeds because they paid the down payment of $50,000 before the marriage, but after that, the proceeds are split 50-50. But the point is, to get a full understanding of the financials, you may want to go out and get an appraisal on a house, or sometimes people have very expensive personal property, jewelry, paintings, things like that, where you need to get an appraisal to understand what it's worth. Or one of the spouses may own a business, so we may need to go out and get a valuation of the business. And generally speaking, for all of these things, we need to find an expert witness who can dig into, who can do an appraisal on the house, or who has an understanding of these sorts of businesses. And there's experts who all they do is business valuation, where they'll dig into the financials of a company and come up with a value. So those are the types of professionals that we would potentially want to enlist to come up with values on assets that aren't necessarily known, so that we can have a full understanding of the financials. And whenever we're going to have an appraisal, or any third party who's coming in to value an asset, we would want to file with it, we put together a disclosure of expert witness that is filed with the court, because ultimately, if we're going to have one of these people testify at trial as to the value of real estate or a business, we're procedurally required to file a disclosure of expert witness to put the other side on notice of this expert, so that they have an opportunity to take the deposition of our expert or go out and get their own expert. So we want to file a disclosure of expert witness with it. Now, just kind of procedurally of how the case progresses. So we initially file all of these pleadings, and really nothing happens for quite some time until the court will schedule what's called a remote resolution plan date, or just a resolution plan date. Right now, we're doing everything virtually, but we'll see how that progresses as time goes on. So at the resolution plan date, it's essentially a meeting between the lawyers and the clients, or if there are no lawyers, it'll be the clients only. And it's a meeting with the family relations office, where they're kind of they're the first step. So family relations are kind of neutral mediator sorts of individuals who work for the court, and they try to help resolve cases and help them move along. So what family relations will do is have these meetings to kind of get an understanding of the issues in the case, to figure out what has to be done next. So some examples are, family relations will be particularly involved if there are custody issues. So let's say, there's two parents who they can't agree on what the visitation schedule is going to be once the divorce is over. Then we would have, at this point, at the resolution plan date, family relations would say, okay, we understand there's going to be a dispute. Let's see if we can offer some services that will help these people resolve their custody disputes. So the court may, family relations may recommend just a mediation or a series of mediation sessions where the parties will meet with somebody from family relations. Generally speaking, the lawyers are not involved, and they will basically hear what both sides have to say, hear what both sides are looking for with regard to custody and visitation, and they'll try to help them reach an agreement. They may reach out, if they may reach out to third parties, they can reach out to the school, they can reach out to, pediatrician, therapists, things like that, to try to get a full understanding of the situation. Generally speaking, they're not going to reach out to third parties during a mediation, but they can, to try to help folks reach an agreement. But ultimately, if they can't reach an agreement, the family relations can also conduct evaluations where they will really do a deep dive into the history of the custody. They'll reach out to third parties and get an understanding of, they'll speak to therapists, people at the school, mental health providers for the parents, not just therapists for the kids. They'll reach out to all sorts of collateral third parties to really get an understanding of the family dynamic. And then ultimately, family relations can make a recommendation about what they think should happen with regard to custody. And, that recommendation would ultimately go to a judge, which the judge would use in, trying to make a determination about what should happen with custody. So that's kind of how the family relations can get involved. So at that initial resolution plan date, they may say, okay, let's schedule these folks for a mediation, and then that process will take, 2-3 months. And then, they'll say, let's schedule the parties for a mediation and come back and, schedule a status conference with the judge, with the court in 3 months. And then, at that point, 3 months later, they would come back and say, okay, we've been able to reach an agreement, and therefore family relations is done, and we can just focus on financials, which I'll get into in a minute. Or family relations may say, we were unable to reach an agreement through mediation. We need to now switch over to doing a custody evaluation. And then, the court will probably, in that situation, schedule the case for another status conference 3 months out. Generally speaking, a custody evaluation can take 3 to 4 months. And then, after that, there'd be another status where the custody evaluation results would be shared with the parties, so that, generally speaking, they're still encouraging people to reach an agreement. And if there is a full evaluation and we know what family relations is going to be recommending, it's easier for parties to reach an agreement, because they kind of see the writing on the wall and say, okay, well, if family relations is recommending a 50-50 schedule, the judge is probably going to follow the recommendation of family relations. So maybe we can, let's reach an agreement rather than spending money on trial. That will often happen. So family relations is constantly trying to help people reach agreements in their case. Now, there's kind of a separate track from family relations being involved, because family relations can be somewhat time consuming. An evaluation takes many months. So sometimes people will separately, instead of going through family relations, they'll have what's called a guardian ad litem appointed. A guardian ad litem is essentially a neutral party who doesn't represent either of the parents. The GAL actually represents the best interest of the child. So the GAL will be, and backing up in the family relations custody evaluation, family relations will also be talking to the child, generally speaking, the child or children, to hear kind of their input and what they think should happen with custody and what they want to do. Now, you're not always going to follow the wishes of the child, but the older a kid gets, the more input, the more the court or family relations are going to listen to them. But it's not, they don't at the end of the day have final say. It's just the older they get, the more their input is listened to. So, but just back to the GAL. So the GAL is a neutral party who will do a lot of the same stuff as what family relations would do through a custody evaluation. So the GAL will meet with the child or children. They'll talk to the school or the therapist of the kids or the therapists of the individual parents. They'll talk to, other third parties who they think are relevant and use that information to essentially make a recommendation. Now, they'll first make the recommendation to the clients, to the parents and the lawyers of the parents, to try to help them reach an agreement. They'll say, all right, similar to what I talked about in the custody evaluation, they say, okay, I've talked to everybody and this is what I think should happen. And when the GAL gives their recommendation, that makes settlement more likely because, again, the parties will know at the end of the day, it's a judge who's making a decision, and the judge is probably going to follow the recommendation of the GAL because the GAL is the person who's neutral and is most familiar with the dynamic of the parents and the kids and what should happen. A judge is ultimately only seeing a little snippet. They're seeing, testimony from the parents, which can often be a he said, she said. So they're really going to listen to the neutral party who doesn't have a dog in the fight, which is usually the GAL or the family relations custody evaluator. And folks will use a GAL. A GAL is quicker. You're not waiting months for family relations to do something. A GAL can generally get in there quicker and deal with issues and meet with people. Now, the GAL does, however, generally cost money, where the parents are splitting, not necessarily always splitting, but you have to pay for a GAL, which, is similar fees to what an attorney costs. So it's an extra cost, which is why parents often want to lean towards using a family relations evaluation instead of a guardian ad litem, just to save on fees. But there are some folks like the Children's Law Center. There are some nonprofit organizations that will have sliding scale GAL fees, or sometimes if parents can qualify for no fees for a GAL. So there are ways to get a guardian ad litem appointed when parties don't have money, but generally speaking, a GAL is being paid for. So that's kind of the custody side of things. But separate from that, a lot of this is financial. And so back to the resolution plan date, they will also triage the financial issues. So they'll potentially schedule a Pendente Lite hearing. If there are some kind of immediate financial issues of, husband is not, paying the mortgage on the house. The husband isn't giving financial, isn't making financial contributions to the wife, or vice versa. Sometimes oftentimes there are the mother or the wife is the primary breadwinner. So those are kind of immediate issues that can't wait until the case is resolved, because somebody may need financial support, or, a motion for exclusive use is generally, sometimes needed right away. So in that situation, at the resolution plan date, one of the parties may say, okay, well, we need an immediate hearing on one of these issues. We need an immediate hearing on the motion for alimony, or we need an immediate hearing on the motion for exclusive use, or an immediate hearing on motion for custody and visitation if the parents are living apart, and they, one parent isn't seeing the kids at all. Let's say a husband is withholding visitation to the wife. In that situation, you're not really going to wait for a custody evaluation, or even you might not wait for a guardian ad litem to get appointed. If it's a situation where one parent isn't seeing the kids, or there's some other emergency, not necessarily emergency, but urgent need that needs to be addressed, then at the resolution plan date, the family relations will basically make a determination saying, okay, we need a hearing on this issue, and they'll schedule the parents for a Pendente Lite hearing, in which case, there'd usually be a couple hours blocked off for a hearing on, these, generally speaking, these motions right here. So that some sort of status quo can be established while the divorce is pending, so that the parents can focus on the more long-term resolution of the case. So taking that aside, after these Pendente Lite issues are resolved and there is a status quo that has been established, at the resolution plan date, the family relations may also determine, okay, there's financial issues that need to be resolved. The parties can't agree on what the alimony payment's going to be. They can't agree on what the division of assets and debts is going to be. And in these resolution plan dates, the family relations may say, okay, well, what does the husband have to say? And, I shouldn't say husband and wife. Sometimes there are, oftentimes there are same-sex couples as well. So what does the plaintiff want to happen? What does the defendant want to happen? And, family relations will sometimes try to bridge that gap and, make recommendations about what they think should happen with alimony or child support. It really depends on the family relations worker you get. Some are more comfortable with these financial issues and kind of facilitating a negotiation. Some aren't. So that, how much you get into the financial negotiations at the resolution plan date really depends. But, and sometimes I should say, sometimes at the resolution plan date, everybody may say, all right, well, we reach an agreement. You may reach an agreement at the resolution plan date, in which case family relations will report to the court, okay, we've got an agreement, and then, say, all right, let's schedule a status conference for 30 days from now, and we can figure out what to do if an agreement hasn't been drafted and submitted to the court by that time. But if there are still financial disputes during the, if it becomes clear at the resolution plan date that there are financial disputes, the court will oftentimes just schedule a judicial pretrial. So a judicial pretrial is basically a meeting where the lawyers will go in and meet with a judge. Generally speaking, the clients are not present for that meeting. It's just the lawyers, and they'll go in and they'll prepare, they'll basically negotiate the financial side of the case. And sometimes they'll negotiate the custody and visitation, but generally speaking, custody and visitation is reserved for family relations to deal with on the track that I had talked about of mediation and or an evaluation. It's left to either family relations or the guardian ad litem. And then the financials are generally on a separate track where there is a judicial pretrial. And there's a number of documents that we need to prepare going into a judicial pretrial. So we come in and submit to the court basically our financial affidavits so that the judge can have a full understanding of the financials of both sides. We'd also submit pretrial memos. It's a very brief, like one-page summary that gives the name of the clients, their age, their health, whether they have any health issues that prevent them from working. It'll provide the names of the children. It'll list the employment history of the parties. It'll kind of list any basic information that we think is relevant to the case and the negotiation. It might list the cause of the breakdown of the marriage. If one person was having an affair, we might put on the pretrial memo that there was infidelity, which caused the breakdown of the marriage. So we would put together a pretrial memo, and then we'd also put together our proposed orders. So basically everything that we're requesting in the divorce. So we put together, our custody and visitation proposal. And again, that's not so much going to be discussed during the judicial pretrial because that's more left to family relations. But we would give our alimony proposal, our child support proposal, what we're proposing on division of assets and debts. We'd give our proposal on what we think should happen with post-secondary educational support, which I'll get into a little bit more in another video. But post-secondary educational support is basically figuring out who's going to pay for how much of the kid's college. In most cases, we'll just say the court will retain jurisdiction over post-secondary educational support, because generally speaking, when a divorce is pending, the kids might be 8 years old and you have no idea, where they're going to be going to college, what college is going to cost at that time, what the financial circumstances of the parties is going to be at that time. So we'll sometimes say the court will retain jurisdiction and essentially kick the can down the road where the parties try to work it out amongst themselves in the future. But if they can't work out, who's going to pay for how much of college, either one of them can bring the other one back to court. But you kind of are, or sometimes the court won't. The parties will agree that they're not going to have the court retain jurisdiction. If some people just feel that I paid for college as a student and really believe that their kids should pay for their own college, or they may know that they don't have the financial resources to pay for college. So parties can agree to do whatever they want with post-secondary educational support. So usually, but if the kids are like of college age or are going to be going to college next year, or they're in college right now, generally speaking, you're going to need to figure out in more detail the specifics of the post-secondary educational support. So that would want to be listed in the proposed orders. Then certain tax issues, who's going to claim the kids on their tax returns, or who's going to get the mortgage interest and tax deductions on their tax returns, things like that. Then, we would put proposals for medical insurance, who's going to pay. Generally speaking, the parties are each responsible for their own medical insurance after a divorce, but you might put in who's going to pay for the medical insurance of the children. So, you need to put that in the divorce agreement. And then, a proposal on a life insurance provision. Generally speaking, if there are children involved, both parents are going to want to have life insurance so that, if one of the parents dies and there's a single parent situation, they have a little bit, obviously you're not going to receive child support from a deceased spouse. So you're going to usually want to have life insurance in place, or, you need life insurance for alimony. If a wife is, or a husband, or, if a spouse is receiving alimony from the other spouse, they're relying on that alimony long-term for financial support, or short-term, but they're relying on the alimony for financial support. And if the alimony obligor, the person paying alimony, dies, the person who is receiving it is kind of out of luck. So that's why we need a life insurance provision in place to insure the alimony. So all of that stuff, and we're also going to want to put together, if there are children involved, you'd want to put together child support guidelines for the pretrial. And we'll get into the child support guidelines in more detail in another video. But generally speaking, child support is just a formula where the income of the parties goes into the formula, and then a number comes out depending on how many kids there are. Now, you can deviate from child support. The most common deviation is deviating from the child support number based on a shared parenting plan. So, if there is a shared parenting plan situation, you're not necessarily going to want to follow the child support guidelines. So the lawyers will go into the judicial pretrial with all of this stuff prepared in the proposals, and both lawyers will make their pitch about what they think should happen with, custody, visitation, alimony, child support, division of assets and debts, etc. And the judge will basically make a recommendation to try to help the parties reach an agreement, to try to help the lawyers reach an agreement. Now, the judge's recommendation is not binding. It's not like the judge in the pretrial has any power to, make their recommendation in order. It's just a recommendation to try to help folks reach an agreement. Generally speaking, clients are inclined to listen to the recommendation of a judge. Judges are experienced and they've handled a lot of cases, and it really helps to resolve cases if you hear what this particular judge thinks they would do in if the case were at trial in front of them. Now, if there is a trial down the road and there has to be a hearing, the judge who handled the pretrial will not handle the trial. So it would be a different judge in an ultimate trial. So that's those are really the two tracks of, how the court and the court system tries to help people reach agreements in cases. It's, on custody and visitation, it's using the family relations office or a guardian ad litem. And then on the financial end, it's more a judge who's trying to help folks reach agreements. Now, there also are some alternative ways to reach agreements, rather than a judicial pretrial. Some courts have special masters where instead of a judge who's doing the facilitation of the negotiations and hearing the proposals of both sides on the financials, it's often a male and a female volunteer attorney. That's just how the special masters are set up, where there's a male and female attorney who are experienced in family law, and they will hear what both sides have to say, and they'll make a recommendation about what they think should happen in the case in order to try to help folks reach an agreement. Or sometimes people, a judicial pretrial is, generally speaking, it's only an hour-long meeting with a judge, and there's only so much you can get out of an hour. And there are sometimes more complicated cases, where you can't get enough done in an hour. So what we can go out and do is get a private mediator, which is, generally speaking, it's a retired judge. There's a lot of retired judges who do this, where they'll take a half a day or a full day and sit down with the lawyers and the clients and try to hash out all of these issues. They'll hear the recommendations, and they'll try to help folks reach agreement on all the financials or the custody stuff. But generally speaking, the private mediations are more dealing with the financials. So those are kind of the tracks of how the court tries to reach a settlement. Now, there are some other steps as we get closer to trial. We may, if we're getting closer to trial, we oftentimes will want to take depositions. And sometimes you'll take depositions before any of the settlement discussions. So a deposition is basically it's an out of court conversation, for lack of a better term, with the party on the other side. So if I'm representing a husband, I may want to take the deposition of the wife to get a full understanding of the background of their case. I want to know about the history of the marriage, the cause of the breakdown of the marriage, whether, ask her, whether there was ever any infidelity by either party, whether there was any, physical abuse, mental abuse, things like that. Because, if you're going to trial, you don't really want to be ambushed and surprised by, the wife saying, that the husband, used to hit her or something like that. You want to know that going into trial, so there aren't any surprises. In a deposition, you also want to, you might want to get a lot of background on financials of, I'll ask a lot about the financial history of the parties, how much, there's a lot, and we'll get into in another video, we'll get into more details on depositions. But we also, it's not just taking depositions of the parties, we may want to take depositions of other witnesses who are going to be testifying at trial, taking depositions of expert witnesses who are going to be presenting at trial. If we represent one spouse and the other spouse has their expert witness who's doing who's going to be testifying as to the value of the business, we're going to want to take that person's deposition to get an understanding of where they're coming from and how they drew their conclusions. And we basically want to know what they're going to say at trial. So those are a lot of the steps as you get closer to trial. Now, ultimately, if we're able to reach an agreement, we would basically just draft up the agreement and submit the agreement to the court, and then the court would finalize the divorce. And there's a number of forms that need to be filed with the agreement in order for the court to approve the agreement, and we'll get into that in a separate video. But most cases do not go to trial. Most cases are resolved with an agreement. So if there is an agreement, that's filed with the court and the case is over. Now, if there's no agreement, ultimately the case goes to trial. And if a case is going to be going to trial, there are certain documents that need to be prepared in advance of trial. It's called trial management compliance. So in advance of trial, about 10 days prior to trial, certain documents need to be submitted to the court. You need to submit a list of any pending motions that are still outstanding. Generally speaking, those are going to be, these motions up here, the Pendente Lite motions. So we need to list any pending motions, and then we also need to submit financial affidavits to the court and to the other side. We need to submit child support guidelines, a list of witnesses. You have to disclose to the other side the witnesses that you're going to be having testify at trial, just because you can't ambush the other side with hidden information. You need to disclose what you're going to be presenting at trial in advance of trial so that the other side can be prepared. So you're supposed to disclose the list of witnesses, the list of exhibits that you're planning to present. Exhibits are basically evidence, bank account statements, text messages, things like that. You need to disclose that in advance. And then you're going to want to disclose your proposed orders. You're going to submit your proposed orders to the court because you put on your case and you have a trial, and ultimately you want to have the written proposed orders that you present to the judge, because the judge is going to be making a decision, and you want that decision to be based off of your proposed orders. So those need to be submitted in advance of the trial, and then ultimately you would have the trial, where kind of the series of how it goes. There's no opening arguments in Connecticut divorce cases. It starts with just testimony. So the plaintiff calls their first witness, and then the defendant or defendant's attorney has an opportunity to cross-examine that witness. And then after that, the plaintiff can then redirect. Basically, you can go back and forth with cross-examining and giving direct examination of each witness. So the plaintiff will then call their next witness, and the plaintiff will call all of their witnesses, and then they will, once they're done with all of their witnesses, then the defendant will have an opportunity to call all of their witnesses. And it's the same thing where there's direct examination and cross-examination. And then after all of the testimony is presented and evidence, the exhibits are presented to the court during the testimony. So after all of the witnesses and evidence is presented, then there's closing arguments where, generally speaking, the plaintiff will submit their closing argument, and after the plaintiff submits their closing argument, then the defendant has an opportunity to present their closing argument, and then the trial is over. And then ultimately, the final step in a divorce case is the judge issuing a decision. Generally speaking, after a trial, the judge is not going to issue a decision verbally from the bench, it's called. Some cases they will issue verbal orders, in more simple cases, but generally speaking, the court is going to hear the case and then basically, say, all right, I'm going to issue my decision, in the future. And they will issue a written decision about, what their orders are and why they've reached their orders, and give some some background on the case. And then that's the conclusion of the case. So a judge has 120 days after the final day of trial to issue a decision. So that's kind of the divorce process in a nutshell from beginning to end. And then we're gonna have some other content that really gets into the details of a lot of these other steps. So you have that information.